Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? From meal breaks to bonuses, employers in the healthcare industry manage some of the most complex workforce problems, including competing federal and state wage and hour laws and regulations. On this episode of We Get Work, we explore how healthcare employers can anticipate and confront some of the most common wage and hour issues in their industry, including classifying exempt and non-exempt employees, appropriately compensating overtime, and overseeing independent contractors. Our hosts today are Daniel Thornton, of counsel in Jackson Lewis's Philadelphia office, and Andrew Belwar, associate in the firm's Washington, D.C. region office, and both members of our Wage and Hour group. Dan and Andrew, the question on everyone's mind today is, what are the key steps healthcare employers can take right now to remain compliant with wage and hour laws, and how does that impact my business?
Thanks, Alicia. I'm thrilled to be here with Andrew to talk about common wage and hour mistakes and pitfalls that we see with a focus on our healthcare clients. We find that proactive review of pay policies and practices is one of the easiest ways to avoid litigation in this area. And with that, I'll pass it off to Andrew.
Thanks, Dan. It's nice to be here with you today. I guess one of the areas that we most frequently see issues pop up is in relation to breaks, and specifically meal breaks. So although the FLSA, Fair Labor Standards Act, this is going to be the act that kind of underlies a lot of the issues we talk about today. Although the FLSA doesn't require breaks, when employers do provide them to employees, as a lot of employers do, there are a couple things that employers need to keep in the back of their mind whenever they're thinking about how to handle these breaks. So especially when it comes to meal breaks, the most important part is that they should be uninterrupted of at least 30 minutes. So employees shouldn't be doing work during them. They shouldn't be called in away from their lunch. It really should be set aside for the employee. So Dan, I think we've talked a couple times about certain issues that have popped up specifically related to this, and it happens a lot during, especially with nurses, right? So they can get called back to perform some kind of emergency procedure, or if there's light staffing, they'll be pulled back onto the floor. But that's where employers can start getting into some hot water.
Yeah, absolutely. And ensuring that breaks are, genuinely duty-free and uninterrupted can be tricky, particularly if someone is on call during the break. And we see this, especially in the healthcare field. And that brings us to kind of the next subpart of this, which is, what do you do when a break does get interrupted, despite your best efforts?
Yeah. So one of the important things that employers are supposed to do is make sure that they have some kind of set procedure for how to compensate an employee for any interrupted meal break. So, it's not like it's the end of the world if somebody does get pulled back onto the floor, but the reality is the employee then has to get paid for that time. And not just the time that they're on the floor, but the time for the entire meal break if it was interrupted before that 30 minutes is up. So one thing that a lot of employers will tend to do is they'll have some kind of slip of paper or some kind of reporting mechanism to make sure that an employee is able to report an interrupted meal break to either their supervisor or to HR. And then at that point, it's important that the supervisor and or HR make sure that the employee gets compensated for that time. So it should be done at the end of that week. Make sure that everything is buttoned up with each pay period. And really the important part is to keep in mind that if it is less than 30 minutes for that break, then it needs to be compensated to the employee. So that's really going to run through a lot of the issues that we see today, too. Is time worked is time that the employee needs to be compensated. So, Dan, you've come across a couple of these issues as well for the beginning and ends of shifts, right?
Yeah, absolutely. And, one other thing on those interruptions is that, it doesn't really matter what mechanism you have, whether that's that paper form or some of those other things you mentioned. Some payroll systems let you, flag it within the system when submitting a time card. The main thing is to ensure that the mechanism is actually used, because we see plenty of cases where the employer says, oh, we have a process, but when you actually investigate, it's used very little or almost never. So having the system in place doesn't matter very much if it's not actually being used, because that's absolutely going to be looked into when there is a claim or an allegation. And yeah, that leads right into the next topic we have on our list, which is the beginnings and ends of shifts and making sure that wage and hour practices there are compliant as well. And one of the most common issues we see here is paying to a schedule rather than to actual hours worked. This is fairly common in some healthcare contexts. We also see it a lot in manufacturing and production facilities. There's a temptation to believe that the schedule is what actually happens and to just pay based on what's scheduled, but reality often differs, and often by quite a bit. And so the best practice, and what we always recommend, is to pay hourly employees, to the punch from when they clock in until when they clock out, and to avoid any kind of rounding or paying to a schedule or anything else that's going to deviate from the actual clocked time, without a reason. It could be that there's a missed punch, someone forgets to clock out and the time keeps running at the end, or they forget to clock in and they're not being paid at the beginning. But that should be corrected. There should be some kind of memo or comment from the manager, the relevant supervisor there, to explain it. In cases other than that, the best practice and the way to avoid headaches in this area really is to just pay people to the punch every time. For hospital-based operations or more intensive care units, there's constant staffing, and paying people to a schedule doesn't make a lot of sense because there are necessary shift handovers. Patients can't just go kind of from one shift to the next without some handover activities, meetings to transfer duties and bring everyone up to speed. And so if you are going to go by a schedule, it often makes sense to have some kind of overlap that's sufficient in time so that those shift transfer activities can all take place, on the clock, because without question, that's all compensable time. Briefing your relief shift or vice versa is always going to be compensable and needs to be on the clock. On a related point, time clock placement can be important here as well. And the best practice, again, is to keep time clocks either at the facility's main entrance or kind of at the perimeter, rather than forcing people to clock in at each duty station or work area, because it may be that there is a lengthy walk to get to the actual time clock. And if a lot of that walk is on the employer's premises, say within a hospital complex, there's potential liability there, particularly under many states' laws that are more aggressive than the FLSA in compensating that time. So the best practice is to pay to the punch and to put time clocks in a location where your employees are clocking in, as soon as they are on your premises.
And Dan, kind of related to that, going back to the potential issues of employees not punching out or having some kind of issue with their punches, that's another opportunity for employers to have some kind of system in place to correct those punches, right? So somebody can talk to HR, talk to their manager, and review their paycheck at the end of each pay period, sign off on it to make sure everything's right. Those are just more opportunities for employers to potentially avoid some of the liability that can come from these issues, right?
100%. And on that note, the policies you have in place are important. And we recognize that the reason for rounding or paying to a schedule is often because of concerns that employees are messing around while on the clock. They come in, they get coffee, they read the newspaper, whatever it is. They talk with their colleagues about whatever, and spend time, and substantial time in the aggregate, not doing compensable work, even though they're clocked in. But the answer to that, and what we always recommend in these cases, is have a vigorous policy that requires you to be doing compensable work when you're on the clock and being paid. And when you see a violation, the way to enforce it is to pay for every minute worked, but to impose discipline consistent with the policy to bring everyone into compliance. You are always going to create a bigger issue by fighting about the compensable time or not paying for time that arguably was worked than by having a clear policy and imposing progressive discipline in a manner that's uniform and consistent. In our experience, it doesn't take a lot of disciplinary effort to get folks in line and to reach an understanding as to what needs to be happening on the clock versus off the clock. And it's always going to be cheaper than dealing with a class or collective action later because the clocking policy was too aggressive.
There's no doubt about that. And actually, one way that a lot of employers do address these pretty early is having a bunch of written policies that they give to employees right when they start. So these can be policies about automatic deductions for meal breaks, for instance. That's one that we see pretty common. There are also a bunch of disciplinary procedures and policies that people can lay out, really a lot of things in a general handbook that employees are supposed to review when they onboard, right? And a lot of times employers will have their employees sign those policies, sign those handbooks, just as an acknowledgement of, yeah, we talked about this at the beginning. And then, it's always important to make sure that employees have access to the handbook too, so they can always check what those policies are. There are trainings, there are informal conversations with managers and HR, a lot of different ways that employers can deal with these kind of issues if they pop up and really prevent the issues from popping up. But as you said, Dan, it's very important to make sure that compensable time is always paid.
Absolutely. And I think we have rounding issues next on our list. Andrew, did you have anything more to say about those?
Yeah. So as you said, Dan, you can typically avoid issues when it comes to rounding by paying people to the punch. So that is paying them for the exact amount of time when they clock in to when they clock out. And that's always the easiest way to avoid any potential liability there. The FLSA does allow for a little bit of rounding. There are a couple different mechanisms to do it, but the important part is that you actually do that in accordance with what the FLSA requires. So in short, you can round, but you have to make sure that you're not doing it improperly. There are 5-minute, 6-minute, and even 15-minute allowances for rounding. But, the important part is if you're halfway through that period, you're supposed to round up. If you're halfway under that, then you're supposed to round down. You can't really finagle the numbers there, right? So if you have like a 15-minute rounding policy and somebody's 11 minutes into that next 15 minutes, you can't then round that down. It might save you a couple bucks in the short term, but as Dan alluded to earlier, the cost of any kind of class or collective action that comes from one of these violations is more than enough reason to make sure that you're complying with the actual law. So just making sure that you are staying true to rounding up and rounding down is a great way to avoid any kind of liability there. So then there are some other issues when it comes to paying people based on bonuses, right? Especially when it comes to hourly work. So Dan, have you come across any experiences with that?
Absolutely. And this is a trickier issue, probably a little more advanced than some of those basics we've been talking about. And it's a source of confusion for employers of all sizes and sophistications, from some of the very largest hospital systems and health networks you can imagine down to local and smaller operations, because the laws and the rules surrounding them are difficult. What the regular rate requires is essentially that all remuneration paid to an employee be included in the calculation of the overtime rate of pay, with certain defined exceptions. And the most common one of these is bonuses. There are certain other payments that need to be included too, and we see some of those in the healthcare context. Shift differentials would be one. Those are very common for 24-hour operations, as many hospitals are, where you have overnight shifts. We often see a shift differential or certain kind of higher acuity units. There are often different differentials and calculations that go into how each hourly shift is paid. Generally speaking, all differentials like that need to be included in the regular rate calculation. All of that needs to go into the numerator, essentially, that's divided by total hours worked to figure out what the regular rate of pay is, so that you can figure out what the appropriate overtime premium for that pay is when the worker goes into overtime for the week. Bonuses are one of the most common issues in this area and one of the most common pitfalls or compliance failures that we see. Because again, the rule is not straightforward. The question that the FLSA and its regulations ask is whether the bonus is discretionary. And what that means is does the employer make the decision both as to the payment of the bonus, the fact that it's being paid, and second, the amount of the bonus? Is the employer deciding all of that relatively close in time to when the bonus is actually paid? So something that's closer to a gift or like a special recognition, like maybe a holiday or Christmas bonus where you decide, early in December what's going to be paid towards the end of December. That's one thing. That's pretty clearly discretionary. But when you have, say, a quarterly bonus, a performance-based bonus, or one thing we've seen a lot are hazard-based bonuses, picking up additional shifts. This was a pretty common practice during the COVID era, picking up more shifts when patient volumes were high and facilities were understaffed. If there's a bonus associated with that and the criteria are very clearly advertised to your employees, almost certainly that is a non-discretionary bonus, and it needs to be included in the regular rate calculation. And when these bonuses can run into the hundreds of dollars, it makes a big difference in terms of the regular rate of pay, as well as the appropriate overtime rate of pay. So it's important to both include everything, and if there is any uncertainty, get a legal opinion. Run it by your lawyer. You'll always thank yourself for doing that rather than kind of wandering in the dark and only figuring out later when there's a claim what's been going on. Andrew, any more thoughts on this topic?
The only thing I was going to mention is that this is especially true for the healthcare industry where there can be a lot of overtime, right? So even if you have a couple $100 bonus, right? If that turns into affecting the overtime rate over the course of maybe 20 overtime hours in a pay period, that can start adding up really quickly.
Yeah, absolutely. Yeah, there are many shift schedules and kind of double shift arrangements that result in a lot of overtime either every week or in alternating weeks. And as Andrew said, that makes it all the more important because it increases the possible damages for every single person and for a class or collective as a whole when one of these issues arises. And with that, I think we can move on to our next topic, which is about the appropriate classification of your employees. And as you probably know, there are exempt and non-exempt employees. Exempt are higher level professionals, generally supervisors or learned professionals or administrative employees like HR and IT. They have to have an applicable exemption, and those employees are exempt from most of the requirements of the FLSA, including the overtime requirements and the minimum wage requirements. But most of the employees we've been talking about and most kind of line level healthcare workers are going to be non-exempt. They're paid on an hourly basis, and they're always going to be entitled to overtime when they exceed 40 hours in a work week. One of the common exemptions in this area is called the learned professional exemption. And this is one where we see a lot of healthcare clients are maybe overly or unduly aggressive with it. It's important to be careful about the exemption factors, to review them against your job descriptions, and to ensure that those factors are actually being met in practice, because fights about misclassification can become very expensive because you're looking at essentially overtime pay entitlement for the entire statutory period, which is 2 or 3 years, depending, under the FLSA, and can be longer under many state laws. So what a learned professional needs are three factors. One is to be paid on a salary basis of at least $684 per week. That's about $35,500 a year. And then the employee's primary duty has to be the performance of work requiring advanced knowledge, which means work that is primarily intellectual in character and includes work requiring the consistent exercise of discretion and judgment. The advanced knowledge has to be in a field of science or learning and be customarily acquired by a prolonged course of specialized intellectual instruction. And where this becomes difficult to apply are for lower level healthcare workers. The doctors of the world, the nurse practitioners, and mid-level providers of the world pretty clearly meet this. All of them have master's degrees or higher level degrees. There's no question that's a prolonged course of intellectual instruction. But a medical assistant or someone who has just a certificate, maybe not even an associate's or bachelor's degree, is probably not going to qualify for an exemption like this. Where to draw the line, again, as we'll say repeatedly throughout our conversation here, get good legal counsel and talk to your lawyer. But the typical place where we draw the line is somewhere around nurses, and it depends on the level of training of the nurse. The U.S. Department of Labor's Wage and Hour Division has guidance on this and provides that registered nurses who are registered by the appropriate state examining board are generally going to meet the duties requirements for the learned professional exemption, meaning that they meet that hardest part of the test. Their primary duty is work requiring advanced knowledge that's primarily intellectual in nature. And as long as they meet the rest of it, that they've acquired it by a prolonged course of intellectual instruction and they're paid sufficiently on a salary basis, they can qualify as learned professionals. But again, every element of that exemption test has to be met. And it's important to review each position as well as what employees are actually doing day to day in making those decisions.
And Dan, one of the frustrating parts, especially for employers, is that the burden is usually on them to demonstrate all this kind of stuff, right? So it's not as easy as just simply saying this person's exempt or pointing to an exemption and just saying, well, I thought that was good enough. In reality, it's not. It's the employer's job to be able to show these are the exact duties that kind of qualify for them. And so that's where talking to an attorney is really helpful there, because you can go through the job description and really the actual functions that the employee is doing in order to match up any of those duties with what's required for the exemption.
Absolutely. And as the U.S. Supreme Court has recently clarified, employers don't have any kind of heightened standard in order to prove that an exemption applies. Some circuits had previously imposed a heightened standard of clear or convincing evidence. The Supreme Court has settled that question and made clear we only have to prove an exemption by a preponderance of the evidence, which means 50% plus a little bit. But that's still a substantial amount of evidence, and you need to be confident based on what the employee is actually doing, what the job description and other documents say, that the nature of their work is exempt and that they're being paid in an appropriate manner that fits with the exemption. And with that, I think we have a little bit to say about the gig economy and classification of independent contractors.
Yeah, exactly. So a lot of people will ask questions about, should my people be employees or should they be independent contractors? Should they be W-2s or 1099s? That's something that a lot of employers and even employees or contractors are really mulling over at the moment. As Dan mentioned, there's a good amount of the gig economy going on where people are trying to work in multiple situations, multiple places of business, all that kind of stuff. And in some ways, it can benefit the individual as well as the person that hires them out. Dan mentioned, especially when it comes to certain exemptions for the FLSA, like the white collar exemptions, that means that those employees are not covered by the FLSA's protections to minimum wage, overtime, things like that. Well, if somebody's a true independent contractor, then they're not even mentioned in the FLSA because it really only applies to employers and employees. And if somebody's an independent contractor, well, they're not your employee. The difficult part is it's not as simple, again, as just labeling somebody as an independent contractor. They actually need to be able to, or the employer needs to actually be able to show that they're an independent contractor. And the way that the DOL looks at this is in what's called the economic realities test. It balances a bunch of different factors that look at the actual relationship between the individual and the place that's hiring them. So it can look at the duration of the time that the people are working there, can look at the degree of control that the owners and operators have over the work that's done by the individual. And it looks at a bunch of different other factors too, like how much of this is really the independent contractor working for themselves, or is it really an employee that's working for the direct benefit of the employer? And so it's not one test. It's not one factor that kind of determines if somebody's an independent contractor or an employee. It balances a bunch of those different factors. There are 6 factors in all, but it's a case-by-case analysis, So again, speaking to an attorney, trying to analyze whether somebody would qualify as an independent contractor or an employee, it's very important for this kind of thing because kind of like with the overtime issue that Dan mentioned earlier, if you have somebody that was misclassified as an independent contractor, then you're going to have to go back. If it is true that they're an employee, you're going to have to go back and pay them back wages, overtime compensation, and maybe some penalties on top of that. So making sure that you have all your ducks in a row when it comes to that classification before it becomes an issue is really important for employers. One area that we're seeing this more and more is, for instance, traveling nurses. That's something that you're going to see in the healthcare industry a lot, and oftentimes they're qualified as independent contractors. The reason being that they have a very short amount of tenure at any particular place that they're working at. They're not as closely monitored by the employer. And really, one of the bigger parts of it is because they're not directly contributing to the growth of the industry. They're kind of just hired in to help out for a short-term need or something like that. And that's something that is usually pretty close to an independent contractor classification. So it should be good. But as soon as an employer starts exerting more control, having a greater length of time for that nurse to be there, possibilities of promotions or other different ways that the independent contractor, who's maybe an employee, can grow in whatever place that they're in, those are all indicators that the DOL might look at in order to say, well, no, this person was actually an employee. So it's important to take a look at each of those possible gray areas for independent contractors and just make sure that everything is in compliance with the FLSA.
Absolutely. We also see this a lot in the home healthcare space, as these home healthcare agencies, some are pretty aggressive in classifying almost the entirety of their workforces as independent contractors. And if it really is a true independent relationship where a provider works for multiple of these agencies and switches back and forth, that may pass muster, but it's an area of vulnerability and a real area of focus for the DOL. We see a lot of investigations that focus here, and often one of the first questions that the DOL has when they do come in to investigate is, do you have independent contractors and how many? And so it's an important area to, again, have all your ducks in a row, seek legal counsel, and be sure that the arrangement reflects the economic reality. It's also important to mention that there are a number of states, including New Jersey, that have more stringent and harder to meet standards that surpass even the economic realities test. So just because you have an arrangement that passes muster under federal law doesn't mean that the legal questions are at an end. So yet another reason to make sure you have good counsel, at your fingertips in order to make sure all your practices are fully compliant in this area.
Yeah, and there can be a number of different areas where, exactly like you mentioned there, Dan, the FLSA has pretty much basic requirements, and then states will come in and provide even more protections for employees. So it's very important to look at not only what the FLSA requires, but to make sure that you're complying with any kind of state laws and regulations as well.
Very true. Well, with that, we thank you all for joining us, and we look forward to providing additional updates throughout the year.
Yep, it was a pleasure speaking with everybody. Hope you enjoyed the show, and stay tuned for more.
Thank you for joining us on We Get Work. Please tune in to our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.